Hi, everybody. Welcome to today's live stream show. I'm going to be joined with Toni Lombardo, tuning in from Boston, Massachusetts. She's a real true crime buff, and she has also watched the Dan Markel murder trials at least 15 times, the whole entire trial, start to finish. So she definitely knows this case very well. You've seen her as a frequent commenter. And Toni prefers not to show her face because she thinks she can read better without having to worry about people looking at her, I guess. So let me go ahead and add her emoji. Thank you for being here, Toni. How are you?
Hi.
Okay.
How are you? I'm actually doing this from my bed as well, so I just don't want to be on camera.
Okay, it's okay. Yeah, as long as you're comfortable and you're reading, then that's what we're after. So
sure
let me go ahead and add this motion to the screen in case people prefer to actually read along for themselves. And there is a page later on in Dan's filing where it has the children's birth date. So that part I'm not going to show on the screen. Okay. Okay. So let's get ready. This is something from, okay, it was filed on January 14th, 2013. In re the marriage of Wendi Adelson, petitioner/wife, and Daniel Markel, respondent/husband. In Leon County Court, Family Law Division, motion for temporary relocation with minor children pending final hearing on relocation. Comes now the petitioner/wife, Wendi Adelson, and moves this court pursuant to Florida statutes section 61.13001 for an expedited hearing, allowing her to temporarily relocate to Coral Springs, Florida, pending final hearing on her relocation request, and would state, number one, the wife filed her petition for dissolution of marriage on September 10th, 2012. Number two, the husband has filed his answer and counter petition for dissolution of marriage on October 4th, 2012. The wife filed her response to that pleading on December 5th, 2012. Number three, on January 14, 2013, the wife has filed her motion for leave to amend her petition to add a relocation request together with her proposed petition for relocation. Okay. It's your turn.
Oh, next page?
Yes.
Number 4. The wife requests that this court grant her an expedited hearing pursuant to Florida statute 61.13001, pursuant to the statute, an evidentiary hearing or non-jury trial on a pleading seeking temporary or permanent relief filed under this section shall be accorded priority on the court's calendar. If a motion seeking temporary relocation is filed, absent good cause, the hearing must occur no later than 30 days after the motion for a temporary relocation is filed. If a notice to set the matter for a non-jury trial is filed, absent good cause, the non-jury trial must occur no later than 90 days after the notice is filed. Number 5. The wife requests she be allowed a temporary relocation with the minor children to Coral Springs because she has been offered a job in Coral Springs with substantially greater income beginning May 1st, 2013. The wife must inform the employers of her ability to relocate and accept this position on a very short notice. Number 6. The wife requests that this court consider her motion and her petition and grant her a hearing so that this court can allow her to relocate with the minor children and meet this deadline. Wherefore, the wife respectfully requests this court, number 1, hold an expedited hearing on her motion to temporarily relocate, and number 2, allow the wife to temporarily relocate to Coral Springs with the minor children and accept her new job while this case is pending.
I hereby certify that a true and correct copy of the foregoing has been furnished by electronic mail on this 14th day of January 2013 to Thomas L. Duggar, Esquire, attorney for husband at email address service@duggarandduggar.com. Kristen Adamson. Attorney at law. She's in Tallahassee, Florida. Attorney for wife. Okay, so that one was very short. So
Yep.
let's move on to Dan's response. Let me get that shared on the screen. Okay, here we go. Are you ready?
I'm ready. Am I
Okay,
up?
go ahead.
Husband's answer to wife's amended petition for dissolution of marriage and request to be allowed to relocate with the minor children, and husband's objection to wife's request to relocate with minor children with prayer for relief. Comes now the respondent husband, Daniel Markel, and files his answer to the wife's amended petition for dissolution of marriage and request to be allowed to relocate with the minor children, and husband's objection to wife's request to relocate with minor children with prayer for relief and in support thereof states.
Number 1, answer 1 through 3. The allegations contained in paragraphs 1 through 3 of the amended petition are admitted. Number 4, the allegation contained in paragraph 4 of the amended petition is denied. The wife has abandoned the husband without exploring adequate alternatives to the dissolution of the parties' marriage, including counseling, and she has determined precipitously that the marriage is irretrievably broken. 5 through 6. The allegations contained in paragraphs 5 and 6 of the amended petition are admitted. Number 7. The husband denies the allegations contained in paragraph 7 of the amended petition. The husband and wife have, since their separation, shared parental responsibility and time sharing equally. However, although the husband seeks continued equal time sharing in Tallahassee, he seeks sole parental responsibility on issues related to the education, religion, and medical upbringing of the children. Number 8, the allegations contained in 8 of the amended petition are denied. The husband affirmatively alleges that the parties have been exercising equal time sharing since the wife's abandonment of the parties' marriage and marital home in early September of 2012. Moreover, prior to the wife's abandonment, the parties enjoyed equal responsibilities with regard to bold and capital and underlined all aspects of their children's lives. Any claim that the wife should have more time sharing than the husband is baseless and unjust.
The allegations contained in paragraph 9 of the amended petition are admitted. The husband affirmatively alleges that child support should be calculated in accordance with the child support guidelines of the state of Florida, taking into account both parties' incomes and the time-sharing schedule established by this court. Number 10. The allegations contained in paragraph 10 of the amended petition are denied. The husband affirmatively alleges that the wife has no ongoing need for any alimony of any nature from the husband. The wife expressly told the husband on September 11, 2012, that she has neither the need nor the desire for alimony because she has a well-paying job, and since September 2012, that job has only increased in pay and stability. Moreover, the wife has incurred unjustified expenses, in part by moving post-separation to a newer and more expensive 4-bedroom home compared to the more modest 3-bedroom marital home. Number 11. As to the allegations contained in paragraph 11 of the amended petition, the husband admits that the parties own real property, tangible and intangible personal property, and liabilities which require the court's determination as to marital status and valuation. But he denies that the wife should be entitled to a 50% distribution the same. Further, the husband affirmatively alleges that he should be entitled to a greater share of the parties' assets, as he is primarily responsible for their acquisition during a marriage in which both parties worked full-time. Number 12. As to the allegations contained in paragraph 12 of the amended petition, the husband admits that the parties have obtained certain assets and incurred certain debts and liabilities during the course of their marriage, but he denies. Can I go? Or
Yeah, just finish the sentence.
okay. But he denies that the assets and debts should be evenly distributed between the parties. Rather, they should be distributed with attention to the manner of acquisition.
Number 13, the allegations contained in paragraph 13 of the amended petition are admitted. The husband further affirmatively alleges that the wife helped herself to non-marital assets, including money and stocks owned prior to marriage, as well as numerous personal non-marital belongings of the husband, such as his luggage, bicycle, tennis racket, and family heirlooms. The wife has refused to return these items or to allow the husband into her home to see what other personal belongings were taken without his permission or acquiescence. Number 2, objection to wife's request to relocate with minor children. A, once examined in context, the bold, all caps, underlined, sole stated reason the wife seeks to relocate with the party's minor children is so she can be closer to her parents. Footnote 1. In a January 2013 electronic communication to husband, wife claimed that she thought relocation was, quote, in the best interest of our kids to be closer to family, more access to a Jewish community, and a happier mom, unquote, sick. She doesn't mention the economic rationale at all, which lies at the heart of her filed petition. And her written petition doesn't mention the, quote, Jewish community, unquote, at all, because the facts are the wife has done nothing to facilitate the children's connection to the Jewish community since the separation. She not only introduced them to a non-kosher diet since the separation, but on her weekends, she refuses to allow husband to continue their pre-separation practice of bringing the children every week to synagogue for services and Sunday school, notwithstanding that husband has offered wife time-sharing offsets in exchange for allowing that to happen. This is bold. Accordingly, the only reasons for the relocation are, quote, happier mom, unquote, and more access to wife's parents. That last sentence is in bold. As the court stated in Coyle versus Coyle, 2009 case, and in numerous other cases, relocation cannot be based simply upon a finding that the relocation would serve the best interests of the relocating parent. Fredman versus Fredman, 2007 case, affirming the trial court's denial of relocation because relocation was found only in the mother's best interest, but not the minor child's.
Where are you?
Let's see. Okay, I'm at the bottom of page 4. So now it's your turn if you want to say the case.
Starting with Barabi versus Clark?
Yeah, okay. Barabi or whatever versus Clark.
Barabi.
Okay, this I won't show because it has the kids' birthdays on it.
Okay. Barabi versus Clark. You want me to stop?
Oh, no, 2004 case, and you can keep reading.
Okay. Where should I read from? Reversing. Can I start at B?
Sure, go ahead.
The husband currently lives in the party's marital home, which the wife with children in tow stealthily and abruptly abandoned in September of 2012. What is that, 2?
Footnote 2, which is at the bottom of the page.
And I should read that first?
Yes.
Okay.
So it can close. Okay.
On September 10th, 2012, after 2 days of not answering husband's calls or texts, wife urgently called husband while he was on a short business trip in New York City and told him, for the first time and over the phone, that she wanted a divorce, notwithstanding the absence of any infidelity, abuse, or neglect by either party. He begged for her not to do anything until he returned, and that he would be on the next flight home. Arriving at home that night, he was shocked. Wife was gone, the boys were gone, the house was half plundered, the Schwab accounts had been raided, and divorce papers were left on the bed. Most importantly, there were no indication of where the wife and children were. Worse, for the first 15 days of the separation, wife refused to give husband any address or phone number for where she lived with the children. Thus, when the children were not with the husband or at the preschool, the husband had no idea where his children were. On September 25th, 2012, wife finally answered husband and his counsel's plea for a proper address, but she gave him a false address that wasn't correct until 4 weeks later. The wife currently resides approximately 10 minutes from the marital home, and both parties live approximately 15 minutes from their children's school. The preschool is also 10 minutes from the FSU College of Law, where both the husband and wife are employed. The parties have 2 minor sons, Benjamin and Lincoln. Prior to the wife's abandonment of the marriage and home, the husband was actively involved as a father. The husband and the wife both work at the FSU College of Law in jobs that provide significant flexibility and opportunity to care for the children. After the birth of the party's first son, the husband had a light teaching load in the fall of 2009. Following the birth of their second son, he was permitted to take a semester of parental leave in the fall of 2011. Throughout the children's lives, the husband has been immersed in parenting, routinely taking them to doctor's appointments, cooking for them, bathing them, and visiting them at their preschool for circle time and daytime meals. He is, in short, an integral and positive part of their daily, in bold, daily lives.
Since the parties' separation, the parties have had equal 50-50 time sharing with the minor children. Since October of 2012, they have had an alternating 2-2-3 time sharing schedule with adjustments and offsets made for travel, work, and other preferences regarding holidays. This rotating time sharing schedule effectively provides each parent with 7 nights out of every 14 with the children. Additionally, the parties have agreed on a communication schedule for time apart and a condition that allows both parents to regularly spend time with the children at their preschool during the week to facilitate ongoing and continuing contact with them. This is now in bold. Therefore, since the parties' separation, the husband has effectively had access to and visits with the children, underlined and bold, 12 out of 14 days. Okay. This is now regular print. Conversely, and importantly, because the husband is committed to including the wife in the life of the children as much as possible, the husband has offered the wife greater access to the children than she has given him by offering Skype calls or in-person visits on any day he has the children so that the parties can co-parent. Unfortunately, to date, the wife largely ignores the children on days and evenings that she does not have responsibility for them.
F. The wife submits as her principal reason to allow relocation a job offer with the personal injury law firm of Gross. Were you going to say don't say it?
Oh, no, you can say that.
Oh.
Yeah, it's only the kids' birth dates that I was concerned about.
The law firm of Grossman and Roth for $115,000 per year. The wife has never worked in a private law firm since her graduation from law school 7 years ago and was recently promoted to and accepted the position of clinical professor at the FSU College of Law. The wife earns at least $100,000 a year in this new position, not including generous benefits and perks. Once cost of living adjustments are made, employment at Grossman and Roth is equivalent to her current pay and may even be less when benefits are figured in. Furthermore, in the new position, she would have to commute more than an hour a day and work substantially longer hours than she does at the FSU College of Law. Moreover, unlike her proposed job, her current position at FSU offers the equivalent of tenure, such that she now has long-term job security. For example, other faculty members at the FSU College of Law with similar positions have been teaching there for almost 20 years each. If the wife were already employed at a law firm such as Grossman and Roth and the FSU College of Law were to offer her the position she now has, it would be obvious that the position she now has would in fact redound to the benefit of the children. In the wife's current position, she teaches students roughly 34 weeks a year, and her teaching obligations require her to be at school for a designated period of 6 hours a week, providing tremendous day-to-day flexibility, much like the husband's job does. The very fact that the wife is seeking to change her current employment and relocate reveals an inability to prioritize the children's well-being, since her proposed employment would not only drastically impede and reduce the husband's access and involvement with the children, but would also substantially reduce her own ability to spend time with the children. At the same time, she would dramatically reduce her own job stability, flexibility, and quality of life. Her proposed new job provides no gain of any significance to the children's best interest. More basically, the economic rationale for the wife's petition is made in bad faith. The wife claims that the job in South Florida at the Grossman Roth firm will pay her more, and that's why she wants to relocate. Nowhere in her petition does she even allege that she is inadequately compensated in Tallahassee to maintain a good quality of life for the children, or more importantly, B, that she made any effort to find a higher paying job in Tallahassee. Her utter failure to show any efforts to find a higher paying job in Tallahassee reveals that she is not at all interested in relocating for financial purposes, but rather that she simply wants to leave Tallahassee after living here since 2005, so she can move on with her life near her parents.
G.
Oh, sorry.
It's okay. Okay, I'll finish this and then you can do the next page. Okay. Okay. The wife's second reason for moving is predicated on the allegation that the children will have more stability and consistency in South Florida. This argument is specious. The children were born in Tallahassee and have lived their entire life in this town, where they have plentiful access to both parents, extended family members who come to visit, and over 50 families with whom they do play dates or celebrate milestones. The only inconsistency and instability in their life has been introduced by the wife's abandonment of the husband and her move to a new and unfamiliar home in the last few months.
Keep going.
Okay. Notwithstanding that abrupt and furtive move, the children are, in the words of Dr. Phelps, the director of the preschool they attend, quote, flourishing. Okay. Go ahead.
Sadly, the inconsistency and instability that the wife has wrought would be hopelessly exacerbated by a relocation to South Florida, requiring, in bold, 6 homes for the children to acculturate to in the space of a couple of years. Indeed, if anyone has introduced instability to the children's lives, it's the wife. First, by unilaterally separating without any notice to husband and absconding with the children to a new and for a while unknown home. Is that a footnote?
Yes, number
Yes.
4.
Footnote
we didn't read number 3. Okay, footnote 3.
Okay, footnote 3 and then footnote 4, right?
Yes.
6 homes. 2 homes in Tallahassee, currently experienced in the last few months, plus B, the proposed new home for the wife, which is her parents' home, plus C, a subsequent new home for the wife. The wife mentioned to the husband that she would only stay with her parents until she got settled in. Furthermore, if relocation were permitted, then the husband would also have to acquire D, short-term, and E, permanent housing in South Florida. And this is footnote 4. Further, the fact that the husband is Canadian is immaterial. He has a green card, and the only reason he is not a U.S. citizen yet is because the wife so abruptly left him in their home without any notice. That it was before he had the chance to file his naturalization papers. Now, because of the wife's unforeseen and abrupt departure from the home, the husband must wait until June of 2014 to naturalize, and he intends on doing that as soon as possible. The husband has lived in the United States all but 2 years since 1991, having spent 2 years abroad between his undergraduate and law school degree in Harvard. Okay, where was I? Gotta find
Okay. If you go back up a little, the paragraph that starts, the wife alleges that the husband.
Are we still on page 23?
Yeah, we're still on the same page. Yeah, in the
23,
middle,
right?
that new paragraph. You want me to read it?
Yes.
Oh, okay. Okay. The wife alleges that the husband wants to move from FSU, but that is false. Prior to the separation and prior to the promotions and job security gained by both the husband and the wife in 2012, the husband considered employment opportunities elsewhere only if they would benefit the couple both as a family. Since the separation, both parents now have excellent and stable jobs. Accordingly, the husband, who is a chaired, tenured, and, beginning August 2013, full professor at the FSU College of Law, has no intention or desire of relocating to take another position. He wants to avoid any further disruption to the lives of his toddlers. Having raised the children here for their whole lives, and as a result of increasing stability and support from the FSU College of Law to both the wife and the husband over the last few years, the husband has no desire to leave the community in which he has spent the last 8 years. Okay, you can go ahead. Are you there?
I am so lost.
Oh, okay. We are now on page 10 out of 23 in the PDF. Okay.
Did you read before H? The wife's third reason?
I can read one more sentence before H. Okay. More urgently, with a separation thrust upon him by surprise and deception, one that he neither wanted nor expected, the husband has no desire to further disrupt the lives of his beloved children with whom he is actively engaged in parenting.
Okay, H. The wife's third reason for moving is to acquire more access to her extended family in South Florida. Ultimately, this is the sole basis of the petition. In bold, but it is legally inadequate. By the wife's own admission, even though her parents reside in South Florida, they have visited in Tallahassee every 3 to 4 weeks since the birth of the children. Many times, the grandparents spent a week to a month or more with the children, either in Tallahassee or elsewhere. Since the parties' separation, the wife's mother and father have spent even more time in Tallahassee. There is no need for the children to be uprooted so that they can have a closer relationship with their maternal grandparents, especially when the relocation would only devastate the husband's parenting role, shrink the family assets, and substantially impede the wife's own parenting opportunities. The wife was offered, and she accepted, a raise and a full-time position at the FSU College of Law in December of 2012, some 3 months after the parties' separation. This, on its face, discredits the false allegations that the husband created a hostile work environment for the wife at the FSU College of Law or in Tallahassee.
Importantly, the wife doesn't mention a single incident or example of this purported hostile environment. Moreover, the husband has used Facebook to congratulate and celebrate the wife on her recent achievements, which many members of the community congratulated her on. So this is footnote 6. Wife's petition also raises other equally spurious issues, such as husband's health and ability to care for the children. Over the nearly 4 years since the children's birth, husband has been able to care for the children, all but perhaps 5 weeks total because of health issues. Wife omits disclosing her own share of health issues, both physical and mental, or travel schedule, that would also be relevant to the court's determination of the children's best interests. Husband was also dumbfounded by wife's claim about unwanted visits to her office. Wife never told husband not to come by prior to late October 2012, and indeed, husband specifically emailed wife on September 18, 2012, quote, "I don't want to bother you at work if that's not a good place for us to chat, so just let me know. If you tell me how/when you'd like to communicate, parentheses, and how often, end parens, I will respect that, semicolon. I hope we can just be gentle and cooperative with each other, end quote. So getting back up to the meat of the writing, J. Under the wife's proposed relocation plan, the husband would have to commute 480 miles for time sharing with the children and be unavailable on the other days and forced to be away from his children for daily breakfasts, special events, or emergencies. This would reduce the husband's parenting opportunities and remove the husband from their daily lives. From the husband's perspective, nothing could be worse. Contrary to the wife's petition, neither the two-bedroom retirement community condo of the husband's aunt and uncle, nor the one-bedroom apartment shared by the husband's 95-year-old uncle and his caregiver, both of which are 30 minutes to an hour away from the wife's proposed new home, have been offered or are feasible for husband and his children to live in. Accordingly, to maintain any time sharing, let alone equivalent time sharing, the husband would have to maintain 2 homes, 2 cars, and weekly airplane fares and parking costs. To engage in the time-sharing arrangement the wife proposes, the husband would be dependent on the College of Law to facilitate this. Do you want to go ahead?
Sure. The
Okay.
College of Law might very well decide or need to assign the husband's teaching or administrative assignments that preclude the kind of time sharing envisioned by the wife. In any event, seen in full, it would be parentally, professionally, financially, and socially destructive for the husband to have to commute roughly 480 miles for work on a weekly basis. K. Under the governing statute, the court must consider the following in making its determination. Number 1, the nature, quality, extent of involvement, and duration of the child's relationship with the parent or other person proposing to relocate with the child and with the non-relocating parent, other persons, siblings, half-siblings, and other significant persons in the child's life. And this is in bold. As the wife acknowledges in her own pleading, the children are close with both the wife and the husband. This has been the case since the children were born. That said, while both parents are loving and devoted caregivers, the wife's erratic and untrustworthy behavior demonstrates an inability to make sound decisions on the children's behalf. End bold. In contrast, the husband can be trusted to consult and include the wife whenever feasible. Indeed, because the husband still wants the children to maintain a close relationship with the wife, the husband currently does not seek more or less than 50% of time sharing, assuming there is no relocation. If the wife decided to relocate without the children, he would find it regrettable, but would then seek to be the primary residential parent. However, the husband strongly opposes any relocation with the children, as this would be devastating to him from a parenting perspective, would be severely detrimental to the children, and would be severely detrimental to the husband from a professional, financial, and social perspective. As stated earlier, he is utterly immersed in the lives of the children and has continued to be since the parties' separation. I'll just read until the yellow, okay?
Sure.
Indeed, the husband makes substantial efforts to spend as much time as possible with the children, as frequently as possible, and works to create conditions under which the wife would be able to see or spend more time with the children.
The children were born and raised in Tallahassee, attend preschool in Tallahassee, and, according to the director of their preschool, are, quote, flourishing, end quote. In short, the children's friends, teachers, and doctors are in Tallahassee, as is their synagogue, which they attend regularly. What's more, the children are still visited by each set of grandparents and other extended family regularly. There is no need or benefit to ripping up the fabric of their lives. Number 2. Quote, the age and developmental stage of the child, the needs of the child, and the likely impact the relocation will have on the child's physical, educational, and emotional development, taking into consideration any special needs of the child, unquote. This is in bold. It is the policy of the Florida legislature that minor children, parentheses, especially very young minor children, end parents, be in frequent, continuing, and meaningful contact with both parents to ensure strong relationships. See Florida Statute 61.13 and Collins versus Collins, a 1999 Florida case, which said generally the younger the child, the greater the need for frequent contact with both parents. Okay. And,
Very true.
okay. Do you want to read the footnote 7?
No, you go ahead.
Okay, great. Courts acknowledge the special importance of maintaining such contact with both parents, in part because of the copious research that supports the significance of fathers, in particular, a view advanced by leading child psychologists, see e.g. Michael E. Lamb, Critical Analysis of Research on Parenting Plans and Children's Well-Being in Parenting Plan Evaluations, Applied Research for the Family Court, a 2012 publication, which said the clear indication of the research is that active paternal involvement, not simply the number or length of meetings between fathers and children, predicts child adjustment. This suggests that post-divorce arrangements should specifically seek to maximize positive and meaningful paternal involvement. See also Michael E. Lamb, The Role of the Father in Child Development, 2010. Dr. Lamb is a psychology professor in the social sciences at the University of Cambridge who has appeared as an expert witness in the United States in various high-profile cases and courts. Okay, so let's get back up there. Okay, you want to go ahead? It says because of the wife's. Yep. Okay.
Because of the wife's proposed new demanding position and the impact relocation would have on the husband, the wife's proposed location would dramatically injure both parents' ability to stay closely and actively involved in the lives of the children. Obviously, this is a vital consideration when considering the children's emotional development. Under the parties' current rotating time-sharing arrangement, the husband cares for the children on half the nights and virtually all of the weekends that he can, and visits them at Creative Preschool, where he spends time with the children on a daily basis. In short, he sees them 12 out of 14 days and has endeavored to reach agreement with the wife to facilitate more access and overnights for both parents. Finally, social science research reveals that relocation is very difficult for children since it deprives them of the social capital or psychological resources that would otherwise be invested in and available to the children from the non-relocating parent. See generally William G. Austin, Relocation Research and Child Custody Disputes. For the family court, Catherine Kuhnel and Leslie Drozd, eds 2012, Oxford University Press. Dr. Austin summarizes the findings of various studies of the pernicious effects of the relocation on the children. Go ahead.
The majority of college students whose parents had divorced wish they could have spent more time with their father or even equal time. Id at 544, quoting, "The importance and unique contributions of fathers have also been empirically established," citing to studies. Quote, "Relocation and economic changes associated with divorce are the two most potent predictors of the children's adjustment," unquote. And they explain 2/3 of the variation between intact families and divorced ones along the dimensions associated with academic achievement, school dropout, child psychological well-being, and teenage pregnancy. Quote, "Multiple moves create more risk, but only one move produces the relocation effect," unquote. In short, relocation is, quote, "is a general risk factor for children of divorce," unquote, citing to various studies, quote, there is a base rate of harm associated with relocation that can be established for children of divorce, unquote. This is another quote. Theory and research suggests that very young children are at higher risk for adjustment problems due to relocation, unquote. Okay, another quote. A past pattern of restrictive or inhibitory gatekeeping by the moving parent makes it more likely that the other parent will have difficulty sustaining a quality relationship with the child, unquote.
Seen in context of this family and the wife's past misuse of access to the children as pawns in her relationship with the husband, there's little reason to be especially hopeful that the children won't be subjected to these harms. Number 3, the feasibility of preserving the relationship between the non-relocating parent or other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing, as well as the financial circumstances of the parties. Semicolon. Whether those factors are sufficient to foster a continuing, meaningful relationship between the child and the non-relocating parent or other person, and the likelihood of compliance with the substitute arrangements by the relocating parent or other person once he or she is out of the jurisdiction of the court. Bold. Since the parties' separation, the husband has worked exceedingly hard to communicate with the wife regarding their time-sharing schedule, and though the parties have exercised equal time-sharing since their separation, it has been difficult to maintain this arrangement with the wife. And bold. The wife's penchant for deception or lack of transparency has manifested itself in various ways that are relevant to determining that she cannot be trusted to keep her commitments with regard to parental time sharing. For example, despite the parties' agreement to same, the wife has, on various occasions, failed to allow the children to Skype with her husband, and she denied the husband his agreed upon time with the children for Halloween of 2012. The wife has consistently failed to honor her other time sharing agreed upon in the parties' emails. She has backed out of agreed upon counseling even when such counseling was intended only to facilitate communication between the parties. Unfortunately, the broken promises, communication withdrawal, and deceitful behavior indicate that the wife really cannot be trusted or consider the children's best interest or the husband's reasonable parenting interest in contrast to hers in any manner that approximates fairness.
Number 4, quote, the child's preference taking into consideration the age and maturity of the child, unquote. Bold, the children are too young to voice any preference. Number 5, quote, whether the relocation will enhance the general quality of life for both the parent or other person seeking the relocation and the child, including but not limited to financial or emotional benefits or educational opportunities, unquote. This is in bold. Despite the wife's allegations to the contrary, the quality of life for the parties and the children will not improve and, in fact, will be severely deteriorated if this court allows the wife to relocate with the parties' minor children to South Florida. Specifically, the wife will commute more, work longer hours, will be away from the children for more hours per day, and will receive less compensation, parentheses, when taking into account the cost of living, end parents, and less job stability and flexibility. Furthermore, relocation would force the husband to expend exorbitant sums to travel to the children for his time sharing. Okay, so this is in regular print. Number 6, quote, the reasons each parent or the other person is seeking or opposing the relocation, unquote. This is in bold again. The wife is seeking to relocate for a better paying job as a law firm associate. However, as explained above, the economic rationale for moving is implausible and was not even mentioned to the husband when the wife broached this in January 2013. Okay, you want to go ahead?
The wife also complains of instability in the children's lives posed by the husband's ambitions, when in fact, The husband is not seeking any other employment at any other institution. The wife wants to move only to facilitate her own preferences to be with her parents in South Florida. The only source of instability in the children's lives is the wife. The husband opposes relocation because it would devastate his parenting role and pose unreasonable financial, professional, and social burdens, as explained above. Number 7. The current employment and economic circumstances of each parent or other person, and whether the proposed relocation is necessary to improve the economic circumstances of the parent or the other person seeking relocation of the child. And this is all in bold, pretty much. Petitions to relocate are sometimes granted over opposing motions when there is economic necessity for a family. Florida Statute 61.13001. 7G. Orta vs. Suarez. 66 SO 3D988. Florida DCA 3D 2011. Wife, this is in parentheses. Wife could not be certified as dentist in Florida, and husband's misrepresentations as to income left her and the child with only $1,100 a month. End of parents. The key issue here, semicolon, there is literally no economic necessity for the wife to relocate to South Florida. Both parties are currently employed in high-paying, stable, and flexible jobs that are conducive to the well-being of the children. Indeed, the wife recently acknowledged in an email that she is grateful that her current position affords her the flexibility to spend time with the children. As explained above, the wife's employment is capitalized, bold, and underlined, not going to be considerably better if she relocates. Her job offer from the law firm in South Florida would require the wife to work substantially more hours for virtually the same amount of income as she currently receives, without any job security. Moreover, she does not even allege that she had trouble making ends meet, or that she's made efforts to find a higher paying job in Tallahassee.
The husband has recently been promoted to full professor and has no intention of leaving Tallahassee. Prior to the birth of the party's children, he did interview with other schools, but that was done with an eye toward improving the fortunes and job stability of the couple. Once FSU made commitments to both the husband and the wife, and once the children were enmeshed in a loving community, there has been no need to look elsewhere. And the husband is very happy raising his children here and doing his teaching and research here. Moreover, any travel that the husband does is completely optional at this point and occurs when the wife has the children, pursuant to their 50-50 time-sharing arrangement. The wife's petition also omits that she travels extensively and was away herself from the children for almost 5 weeks during the spring of 2012 alone. Number 8, quote, that the relocation is sought in good faith and the extent to which the objecting parent has fulfilled his or her financial obligations to the parent or other person seeking, including child support, spousal support, and marital property and marital debt obligations, unquote. This is in bold. Because there are numerous false statements in the petition to relocate, and because the wife's behavior, both generally and specifically, surrounding the filing of the petition to relocate, reveals deception, lack of integrity, and other instances of bad faith, this court, which acts in equity, should look at the wife as having unclean hands. By contrast, the husband has diligently sought to include the wife in all decision-making and has also fulfilled his financial obligations.
Number 9, in quotes, the career and other opportunities available to the objecting parent or other person if the relocation occurs, end quote. In bold, the husband is a tenured full professor with a chair on the best law faculty in Florida. No other school in Florida has offered him, or could offer him, in parentheses, the same package of compensation, benefits, and research opportunities as FSU. And this is in bold. Moreover, at the wife's request prior to the birth of the children, the husband previously sought employment with the University of Miami School of Law, but they had no positions available for him. In short, the husband should be able to maintain his current employment, which enables him to remain a devoted and doting father to his children. Prayer for relief. This court should dismiss the petition to relocate for failure to establish the predicate for a cognizable claim to relocate. Indeed, the wife, who unilaterally helped herself to $400,000 of assets she only barely contributed to, should be forced to bear the full legal costs of this frivolous petition, which emerged during a period in which the wife lulled the husband into believing that they could resolve most of their issues amicably and with little outside intervention. Finally, if the wife is willing to stay in Tallahassee, then this court should award time sharing on a rotating basis of a 50-50 principle, but should award decision-making authority over education, medical, and religious matters solely to the husband, and decision-making on all other matters to the parties jointly. Go ahead.
If the wife moves to South Florida to take this proposed job, then the children should remain in Tallahassee with husband on a full-time basis, and the wife can stay in or near the marital home and visit or watch the children at least every other weekend, with more time based on mutual consent and any travel costs being borne by wife. Additionally, the husband will allow the wife to have the children in South Florida under such a plan each year. Number 1, for 1 week around mid-March, 2, 1 week around July 4th, 3, 1 week around Thanksgiving, and 4, 2 weeks around Christmas. The expenses of transporting the children would be shared like other child-rearing expenses. Dated this 20th day of February 2013. Daniel Markel, respondent/husband, Duggar and Duggar, PA, Thomas L. Duggar. He's an attorney in Tallahassee, Florida. And this is verified by him with a notary signature on the same day and a certificate of service. So that's it. Okay. Thank you, Toni. Thank you very much for your help. I can't do it without you.
Well, that's not it. We're going to come back for the rest, right?
Yeah, that's right. Because so Dan, being the law professor that he was, he created this big memorandum of law. So he filed a brief to support his response. So that's kind of a long document. It is not anywhere close to 700 pages. I don't know who said he would file things that were 700 pages long, but it's not. So Toni, hopefully we can find another date this upcoming week if you can still help. Yeah. Thank you. Do you want to stay on to discuss whatever comments people made? Okay.
Yeah, I didn't get a chance to read any comments.
Oh, okay. Can you see them?
Yeah, now I can, because I'm paying attention now.
Okay, great. Okay, yeah, now I'm paying attention to the comments. So thank you guys. Thanks, Angela. JPJ, Fancy Fiction is here. Saw a photo of Wendi and Charlie vacationing in Colombia together. Really? Wasn't he busy going to see certain young ladies in Colombia? I wonder when that was. Okay.
Colombia. I thought he liked the Philippines.
No, apparently, just based on the police interview of Lacoste, that supposedly Charlie would also go on sex tours to South America, where he would, be doing stuff with young girls or young ladies.
Oh my God.
Yeah, so it wasn't just the Philippines. It wasn't just wherever, Thailand, Vietnam, South Korea, wherever else he might have been running around. So, yeah. So Richard, hi Richard, he wants to know who took care of the kids when she went to Colombia. I don't know when that was. Was it
probably
before
her mother?
Huh?
Probably her mother.
Yeah. It seems like her parents, especially the mom, ended up doing a lot of the child rearing.
A lot.
Yeah. Okay. Hi, Mortgage Gal. She says it's so selfish to walk away from marriage with young children and then want to uproot them. She is very selfish. Yeah, and these types of motions get denied all the time. It's very, very rare, especially if the father or the other parent has been pretty involved with raising the child, it's pretty unlikely that a judge would let the other person just move away for a job that the person wants, or because the other parent wants to be closer to their own parents. Yeah, so it's kind of like a ridiculous motion, in my opinion.
Kind of like a 12-year-old, just like Lacoste said, she's a baby. She can't be by herself.
Yeah, or she needed the help of her parents to do anything.
We need mommy.
Yeah. I thought Charlie was going to his dying friend in Colombia to have one last time of having fun. Yeah, that was his idea on the phone call with his other friend, right?
Just because that might be a good night to him, might not be a good night to the person he was going to give it to.
Yeah, the dying friend who has a wife and
lock him in a hotel room with a bunch of
yeah, and a bunch of cocaine, like lumps of cocaine. Yeah,
I mean, maybe he wouldn't want to do that.
Yeah, that's Charlie's idea of a great way to die, right? Yeah, with a
Right.
bunch of hookers and cocaine. Yeah, okay. Shows you what kind of person he is. Yeah, paper thin. That guy was married with twins. Supposedly he didn't get along with his wife, so that makes sense. Yeah, that's based on what Charlie was saying on those wiretapped phone calls, right? Michael Palmer says, fancy fiction. Charlie and his mom had a very strange relationship. The way they talked to each other was cringeworthy, almost flirty with each other, and bizarre, at least in my opinion.
It was bizarre, the way that how close they were and the things they talked about.
Mm-hmm. Yeah, and the fact that he had no qualms just saying all these rude, obnoxious things to his mom, calling